We'll be speaking to you today about the appointed representatives regime. My name's Ian Tattersall. I'm a senior associate in our insurance disputes team, and I mainly deal with claims against lawyers, accountants, and brokers. I'm joined today by my colleague, Rachel McDonnell. Rachel, would you like to introduce yourself?
Yeah, of course. Hi, everyone. I'm Rachel McDonald. I'm a partner in the disputes group here at Mills and Reeve. I have a general commercial disputes background, but a particular specialism in financial services contentious issues, particularly FCA regulatory enforcement actions and interventions.
Okay, just a couple of housekeeping points before we begin. The session is being recorded today, but whilst you can see us, we can't see you. So don't worry if you've got children running around being noisy in the background. Just the second point, we've got time for a Q&A session at the end. So if you've got any questions, please post them in the Q&A box at the bottom of your screen, and we'll answer them if we have time. So I'm just going to hand over to Rachel now, who's just going to take us through the overview.
Great, thanks, Ian. So you can see the objectives there on the screen. In the next 25, 30 minutes or so, I will be focusing on what are appointed representatives, why has the FCA had so many concerns about them, what rules did it introduce in December 2022 to address this? And then what I want to spend a bit of time looking at is the feedback that the FCA has given basically on how well those rules are working. And that feedback came in a webinar form in April this year, and then a statement in September this year. I just want to start by saying this is a pretty technical area and there are lots of different regulatory obligations and reporting requirements. What I want to do today is really avoid simply listing those obligations because we're all very able to read for ourselves. And if it got very technical, I'm sure you'd all seek proper advice. What I really want to do is focus on providing an understanding of the regime in context, and in particular how these things can play out in practice and what the real drivers from an FCA perspective are.
Okay, so there's a lot of talk about appointed representatives, with some presenting this as a way around the regulations. Could we just start with the basics, Rachel, on what an appointed representative is?
Of course, taking it right back to first principles, to carry on regulated activities in the UK, for example, arranging contracts of insurance, an entity must either be authorised directly by the FCA or exempt. And put simply, a person who's an appointed representative is exempt. They are a person who conducts regulated activities and acts on behalf of a firm that is directly authorised by the FCA, known as the principal. And you can see on the slide there a very sort of crude example. Now, there are all sorts of requirements that the AR must follow in order to allow it to get that exempt status. So, for example, they need to carry on the business for which their principal has accepted responsibility in writing. So you need an AR agreement, a contract, and you need to comply with the requirements as they may be prescribed. And the diagram there obviously shows one sort of AR relationship, but more often than not, the principal firm will have a number of ARs.
So if it's not right, so it's not a way around the regulations. In that case, why do firms do it? What are the benefits here?
Yeah, there are lots of benefits to the structure. I mean, the sort of obvious one is that there's no need for the appointed representative to become directly authorised. And for those of you who have gone through the process, you can know that it can be time consuming and expensive, and it can take months to go through. And that in turn means sort of reduced compliance costs for ARs, no regulatory capital requirements, no need to satisfy minimum solvency requirements or take out professional indemnity insurance. So from an AR perspective, lots of good benefits there. And for principals, it easily and quickly enables them to distribute through third parties. In the insurance space, it can provide insurers with access to niche markets really quickly. And it's a good way to introduce new business lines and test them to work out whether that's something that you want to sort of get into in greater depth without the investment of sort of setting up a directly authorised entity.
So we talked about the benefits and the positives. Is it all good news, or are there any drawbacks to the appointed representatives?
I guess there's always drawbacks, aren't there, Ian? And I think we wouldn't be talking about them today in this context
Yeah,
if there weren't.
quite a boring session.
Um, so the principal is the one that has the regulatory permissions, and it's the one that has to take responsibility in writing for the actions of its ARs. So it's basically responsible for them, and that can leave principals exposed to significant regulatory and civil actions depending on the activities of their ARs. To put it into context, there are currently, as I understand it, around 9,000 appointed representatives in the insurance sector alone. And that responsibility imposes a significant burden on the principal in terms of costs and time and monitoring and ensuring that the AR isn't causing the principal, to be in breach of FCA rules. So the greater the number of ARs, the greater the burden. And so you can see on the screen there, back in 2022, the FCA found that principals caused between 50 and 400% more supervisory cases than non-principals. And it's really proven fertile ground for enforcement actions. I worked on one of the key cases in this area as long ago as 2015, and I acted for the CEO of a compliance network involving hundreds of appointed representatives. The same issues arose in that case as the ones that have been talked about and included in the rules back in December 2022 and are still being looked at by the FCA today. So insufficient monitoring and oversight, and a real lack of understanding about the market and the structure and what those responsibilities look like in practice. So now in the case I just mentioned, the CEO was ultimately fined around £90,000 after several years of enforcement action, which ended with a form of trial in the upper tribunal and a ban from carrying out a significant influence function. So the challenges with the AR regime are really not to be underestimated.
So if there's an ongoing issue here and a growing recognition of the problems with appointed representatives, what's been the key barrier in addressing those concerns?
So I think there it's probably multifaceted, but there was this sort of lack of understanding from principals about what they needed to do, and a lack of prescription from the FCA, and perhaps most importantly, sort of a lack of data and reporting on ARs and what they were doing. So the FCA, to an extent, didn't really know what it was dealing with and what the core issues were. And I think that's probably why you ended up being led towards this rules in December 2022, and you can see there an extract from the FCA website. I'm not going to take you to the FCA handbook, don't worry, and I'm not going to read out everything that's on the screen, but it's really making it more prescriptive in terms of requiring principals to provide additional information about their appointed representatives, making additional notifications, and really clarifying and enhancing the FCA's expectations of principals and their responsibilities. So you can see, it actually goes on to the next slide, all of the different things that you need to do. And I'm not going to go through each of them today, don't worry. But I will come back to some of those key components later in the session, because those are the things that the FCA was focusing on in its feedback.
Yeah. So we've looked at the principal's obligations here and the risks they're taking on. Hearing this, I think a lot of ARs will be forgiven for thinking, well, this is all very interesting, Rachel, but if the principal's taking on all the risk, what's it got to do with me then?
Yeah, I can see that. I really can. The principal firm does have the regulatory obligations, but there is, of course, a trickle-down effect. So it's within everyone's interest to ensure compliance without sounding trite. But the new obligations, or shouldn't call them new anymore, they're nearly 2 years old, but the obligations on principals means that it's really not within their gift to allow their appointed representatives to continue acting in a non-compliant manner. So principals are now obliged to consider termination, for example, in a number of different situations, and one of which is where there's a problem that cannot be remediated by the AR in a reasonable time period. If the principal doesn't consider termination, then they're going to come under criticism for not doing so. So for an AR as well, it really, what strikes me as key is that there are the prescribed activities, so the regulated activities for which the principal has undertaken responsibility. But if the AR is undertaking work outside of those activities, then the principal isn't going to be responsible for that.
Yeah.
Um,
Can we
the
just
AR is.
Yeah, can we just pause there? So the AR is not FCA authorized. So in that case, is this quite serious?
Yeah, exactly.
Mm.
Because what that means is the AR is not entitled to rely on that exemption anymore. Um, because they're carrying out a regulated activity for which they don't have permission from the principal to carry out. And they're not directly authorised. So they are actually in breach of the general prohibition, and that is a criminal offence. If we just have a quick look on the screen there at the two scenarios, you've got consumers and commercial counterparties. We've had plenty of situations where consumers or end customers have suffered losses, and there are questions about where the liability falls. And it can often depend on the terms of the AR agreement that's in place between the appointed representative and the principal, and particularly whether the AR was acting within scope. So we were just talking then about what exactly is the AR doing, and it's been put in the case law as the what and the how. And broadly, that means what activity is the AR carrying out? Now, if that's within the prescribed activities in the AR agreement, then the principal is responsible, regardless of the how that activity is being carried out. And in those cases, you may have a situation where both the AR and the principal firm, in certain contexts, are at risk of claims by consumers.
And if the AR is undertaking work out of scope, does that mean the principal may be off the hook for any associated claims by consumers? Can they wash their hands of them?
I mean, I wouldn't put it that
Mm,
strongly, but
mm,
I think there's definitely greater arguments there from a principal's perspective, because ultimately the AR was undertaking work that wasn't within its authority to do so, and that creates real problems from the AR's perspective, and also from an indemnity perspective as well in terms of any
mm,
insurance.
mm.
So just moving briefly on to talk about the angry looking counterparty example. The last example there, the counterparty. So we had this situation last year in an insurance distribution chain where the AR wasn't operating as it should have been. In fact, it was in financial distress. Actually, arguably, it wasn't able to comply. So it wasn't enough for us just to be saying, as the angry counterparty, do your job. They didn't have the ability to do that. And so in those situations, as many of us know so well, you really struggle to get the leverage that you need, because ultimately they know that you don't want, the only other option is sort of insolvency proceedings, which often are not a great outcome for anyone. But in that scenario, because there was a principal firm in play, we were able to approach the principal and ask some searching questions based on its own regulatory obligations. So, for example, had it considered terminating the agreement, and whether it should be stepping in to ensure the AR would or could perform? Because really, you can focus very much on the end customers and the impact on them to try to get that leverage. So it can provide some really useful negotiating points to resolve an issue.
So it looks like this issue is still firmly on the FCA's radar. Could you tell us about the developments we've seen this year?
Yeah. So at the outset, I said, we've had two kind of sets of feedback, I would say, this year. One in April, where the FCA gave a webinar focused on the FCA's expectations of principal firms. And it was an interesting panel session, actually, and if it's still available online if anyone wants to watch it. And then in September, we had a sort of shorter published feedback on the results of the FCA's recent survey and review work. That is also worth a read and actually a bit shorter. So might be easier for people to digest. Um, Worth noting that as part of this, survey, the FCA had contacted 250 principal firms to conduct telephone questionnaires, and actually 23 firms with a in-depth assessment. So it was a decent cross section of the area. What I wanted to do before looking at some of the more specific points was to draw out a few of the key takeaways, both from the webinar and then build on that with some of the comments coming out of the review. And you can see on the screen there, we've got some key themes. And as with most things these days, the FCA right up top mentioned the consumer duty and underlined that it also applies to activities of ARs, and that principal firms need to make sure that ARs are complying with the consumer duty, and that's forming part of its monitoring as well. Um, Secondly, this isn't something that's going to go away. There's a real emphasis on a continuous improvement cycle. It's not a sort of once and done. There was a real emphasis on assessing, reviewing, making changes, coming back, checking whether those changes worked, reviewing again. And that's, part of that sort of annual review, annual assessment, ongoing process. You can see on the top there, audit trail and records. It wouldn't be FCA feedback if it didn't talk about an audit trail and having records to evidence compliance. The FCA's view has long been, if you can't evidence it, it didn't happen. So actually, as much as anything else, you can do all the right things, but if you can't show you did them, then you won't get the credit for it. And then just also coming out of the survey, this feeling that firms are sort of overconfident. So 96% were saying that they were very confident they were implementing the new rules. I think it's fair to say the FCA didn't share that confidence. Even though most were completing reviews and self-assessments, the FCA didn't think that many of them were particularly good quality. And it goes back to that sort of, taking a more detailed and holistic approach. And we'll come on to that now, looking at sort of 4 areas that the FCA is focused on and thinking about how those general themes apply. I want to focus on the key areas that the FCA flagged. They did flag many others, so it's worth going back to the source. But really, in all of them, they talked about the management information that principal firms should be looking at to assess compliance and progress. Wanted to flag some points here. So the first one is around annual principal self-assessments.
Yeah, what's that involve?
So so in addition to the annual AR reviews, principals themselves need to be conducting a self-assessment of their own ability to oversee ARs, which is to be signed off by the principal's governing body. And now that's a holistic review to spot risks and gaps and looking at different management information. So, do you have enough staff to make sure that you're monitoring everything? How's your revenue changes been? What are your complaints? And those assessments need to be properly documented. The FCA focused again on the fact that actually, even if you had one of those assessments, a lot of the time the principals were conducting a bit of a tick box approach. And they were referencing, templates which really weren't covering off all the points that were required to be considered as part of the supervision manual in the FCA's handbook.
Yeah. Moving on to the second one, monitoring AR growth, what we're talking about there.
This is looking at what your ARs are doing and how that's changing and how the oversight is appropriate. And it is treated distinctly. Of course, it will be covered in an annual review process, but it's an ongoing obligation. And they give good examples of good and bad practices in each of these areas, and they're worth a look. But here you're thinking about regular actual visits out to see your ARs, to discuss the business model, their growth and their target markets, and really drilling down into some key management information, new business register, financial information, complaints records, etc. One of the things that was flagged as part of this feedback was around termination considerations. So in its annual report this year, the FCA said that their supervisory teams had seen principals terminating relationships with approximately 300 introducer ARs and 350 full ARs, which the FCA saw as a good thing in terms of it helping to mitigate actual or potential harm to consumers, i.e., principals are using those termination rights when they think it's appropriate. Then thirdly, yeah, you've got annual reviews of ARs, which is essentially just checking that the AR is still suitable to be your appointed representative.
And does the need for annual reviews apply to introducer appointed representatives? And more importantly, can you remind us what that is, what an introducer appointed representative is?
Sure. So no, it doesn't apply to introducer appointed representatives, but they do need to be included in the annual self-assessment that the principal is conducting to make sure that they remain able to monitor their IARs. And essentially, it's a much narrower subset of appointed representatives who only have permission to introduce arrangements. And essentially what that means is often it's, either the vet putting flyers in the veterinary surgery or something of that nature. So there's a much lower risk profile there.
Yeah. And just the last one, monitoring scope. What's the FCA expecting here?
I think it's pretty much what it says on the tin. So monitoring the scope of the AR's activities and making sure that they are not undertaking regulated activities outside of that. So it goes back to that sort of risk sharing, risk profiling that we were talking about earlier. And it's although it is part of the annual review process, it's not just a yearly process. And so what you're really looking for there is making sure, and as it should be, that your AR agreement is very clear. But then really looking at what they're doing on the ground, because it's one thing that your agreement says, oh, you might, this is the only activity for which you have permission. But actually, it's very, very easy, as we all know, to stray outside of that area. Especially for people who are less sophisticated, knowing what really is a regulated activity or not. So principals are expected to really get under the skin of what they're doing in practice. So sample file checks, call script reviews, and taking that sort of risk-based approach.
So I just moved to this slide with the key takeaway. So clearly this isn't an issue that's going to go away. Could you run us through some key takeaways for today?
Of course. So hopefully these themes have been coming through as we've been talking, but ultimately principals needs to have a robust understanding of all the activities their ARs are undertaking, um, not just, what they think they're doing. They need to know on the ground. This is not a tick box exercise. It's a holistic approach, one of continuous improvement. As ever, oversight must be supported by evidence and an audit trail. And then finally, this is an ongoing process. So the FCA's review work on this, will continue and we can expect more feedback.
So I think we've got time for a couple of questions. I'm just going to ask the first two in front of me. So the first question, Rachel, does
Mhm.
the senior managers and certification regime apply to ARs?
Good question. No, it doesn't apply to ARs. And the reason is that the relevant enabling legislation doesn't give the FCA the power to extend it to ARs. And there is a certain sort of logic to that, I think, really. The principal firm is the regulated entity, not the AR. So it's responsible for everything that goes on within the AR, um, including, compliance with the regulations. So it's all about responsibility and accountability. And it's not unreasonable, I think, that those remain with the principal firm. I think it would be quite difficult for
Mm,
ARs then to sort of take up that mantle.
mm. And the second question, you mentioned termination of the relationship with the appointed representative a couple of times. Could you just explain to us how that would actually work?
Yeah, I mean, it's logistically can be really, really tricky, and it was raised in the FCA's recent feedback. And ultimately, I was talking about that leverage position earlier about termination and stepping in and so on and so forth. But you need to make sure that you're protecting the ultimate end user's interests and protecting them. So if you do decide to terminate, then the principal needs to take all reasonable steps to make sure there's an orderly winding down of any relevant business, which is really tricky, particularly if the AR is in financial distress and so isn't able to sort of pick up the mantle. But the questions that you need to ask yourself really first and foremost is what's the potential impact on customers and how are you going to sort of reduce that impact? The FCA talked about a really good example of good practice being having a clear offboarding policy where issues can't be rectified, and also having that clear mechanism to consider when termination might be appropriate. Because really, I was using it in a disputes context last year, but the principal itself should have been asking itself those questions too. Knowing when those questions need to be triggered is really important.
Yeah. Thanks, Rachel. So that brings us to the end of today's session. Thanks for joining us. When we sign off, a feedback form will just pop up on your screens, on your screen. We'd be very grateful if you could complete that. Feel free to include any topics you'd like us to consider speaking about, or if you'd like us to provide you with a more detailed approach to the subject, let us know. We can communicate by email. Thank you.
Thanks so much.